Well, good evening, everyone. Just to let you all know that this is live streamed on YouTube as well. Welcome all our YouTube viewers, and thanks everyone for joining this Zoom session tonight. Whilst people are still coming on board, I'm just going to go through some of the motions. We will get to the questions, later in the session. Please just bear with us. We've already received a lot of queries and questions that we'll try to get to. But I think for the sake of information and just understanding that we've got people from all over South Africa that is tuning in tonight, we are very grateful for that, and that we would like to just get through the process on the topic tonight before we field all those questions. So my municipal bill skyrocketed and it is inaccurate. So the question is, what can I do now? Many of you may be sitting, with these inaccurate bills, and you have received this from your municipality and you are being threatened that your electricity and water will be cut if you don't pay. So if so, this webinar may be just for you. But what this is not for, and who it's not for, are folks who believe they can abuse the system by declaring a dispute or to try just avoiding paying municipal dues. We want to ensure that we respect the law and that we are all abiding to that. This webinar is here to inform you on how to deal with the issue of a bill that is inaccurate and what your rights are. So I just want to also disclaim that as the panelists and our organizations, we don't accept any liability for the usage or abuse of an application of this information. So I want to thank you and welcome you all tonight. I'm Julius Kleinans. I'm the Executive Manager for Local Government at OUTA, also representing our Community Action Network initiative, which focuses on organizing and empowering and enabling communities throughout South Africa to meaningfully participate in local government affairs, as well as JoburgCAN, which is an umbrella body and network of residents and community organizations within the city of Johannesburg. Joining me tonight is Chantal Gladwin-Wood, who is a partner at Schindlers Attorneys. She specializes in the field of local government and property law. And thank you, Chantal and Schindlers, for availing yourselves tonight to help us as ordinary citizens to get a better understanding on what our rights are and how we can be part of keeping our municipalities honest, but also be law-abiding citizens in the process. Thank you so much for joining us, Chantal.
Thanks for having me, and thanks for the opportunity. It's a passion of mine to empower members of the public with the knowledge of what their rights are in relation to municipalities. We all live somewhere, and we all get services like electricity and water, well, when they're available and when we can afford them, from somewhere. And this relationship between a consumer and a municipality is one of the most important and fundamental in our society. So I'm very, very glad. Thank you guys for the opportunity for me to be able to empower people.
Thanks, Chantal. Municipalities have the right to levy fees and tariffs for services rendered. These tariffs are governed by municipal legislation and their bylaws and policies. But please help us understand a bit. Let's get into the basics. What's a basic municipal bill? When it comes to levies and tariffs, what's the difference between the two? And what are the rights and responsibilities of consumers with regards to municipal accounts?
So I think let's start with the typical kinds of things that you would find on your municipal bill. So if you are the owner of land, you would normally get a rates charge. And the rates charge is a specific kind of charge in law, which we refer to as a tax. It only prescribes after 30 years, which means that a municipality can come after you essentially for 30 years to get payment of that amount if you haven't paid it. And it is controlled by the regulations set out in the Local Government Municipal Property Rates Act. Now, this is quite a special type of charge, and it's kind of on its own because it's so special, and it's got its own law specifically that deals with it. So that's property rates, and that's what you would find on an owner's account. Now, when you get the other types of charges, which I'm going to discuss, which you typically find in a bill, they're not always on every single account. It depends A, whether it's a tenant account, in which case you're not going to get charges that are specific to owners like rates. Or
Is
it
the power
depends
gone off?
or it depends on what kind of property you have, and it depends on what services you're using at the property. So typically what you would find is that you have two charges, which municipalities and most academics, everyone in South Africa almost, except for one or two guys, think that they are taxes. So they prescribe after 30 years, and this is for refuse and for sewer. Now, most people think that refuse charges, so that's for the collection of your rubbish, and your sewer, that's for the ability to connect to the municipal sewer system. Most people think that these are services that a municipality provides and that they have a choice whether to pay for those charges or not. But technically speaking, in terms of the law as it stands today, in any event, in its unamended form, these types of charges are taxes, which means you have to pay them just like your property rates for the pleasure of owning a property, and it's not based on whether you get any services back for those. Now, when it comes to electricity and to water, those are two different types of charges. These are not taxes. These are what we call fees. These are your classic services where you only pay when you consume and you pay for what you consume. So you mentioned a word earlier, Julius, you used the word tariffs. Now, a tariff is kind of like a municipality's price sheet or its menu. So when you go to a restaurant, you can choose, oh, I'm going to have a cappuccino because it's going to cost me 20 Rand, whereas if I have a whiskey, it's going to cost me 50 Rand. So every municipality every year, as part of their budgeting and their public comment process, they put out a list of all the charges that that municipality has, whether they are charges for taxes, which include your rates, your sewer, and your refuse, or whether they are charges for services like electricity or water, or any other services. Like you could have the charge to bury someone in a cemetery, which is municipal, or the charge to take out a book at a municipal library. So these are the kinds of things that you'll find on your municipal account. And as I say, it depends whether you are a tenant or an owner. It depends whether you've opened an account with the municipality for services like electricity, which you can voluntarily elect to get from the municipality. And it depends on what type of property it is that you have. That was the first bit of your question. So those are your typical kinds of charges that you'd find on an account. The second bit of your question was, what are the rights and responsibilities of consumers in relation to their accounts? So first and foremost, I actually want to start with the rights and responsibilities of the municipality, and then I'll move to the consumer in a second. But in essence, a municipality is obliged by law, meaning it doesn't have a choice. It has to provide services to the people who live within its jurisdiction. And a lot of the time, those people can't actually afford it. And the municipality still has to provide those services. So that's the first thing to consider. The second thing to consider is that a municipality is given a lot of empowerment in law to collect the charges that it bills people. And municipalities at the moment are only using a tiny little fraction of that power. So they have lots of opportunities available to them to collect their money, but unfortunately, they only like 2 or 3 of these mechanisms, and so they're not collecting everything they need to. And this is a massive problem in South Africa, because if our municipalities don't have the money they need, they can't provide the services to the people in their jurisdictions. And then you get things like potholes and water services failing and electricity maintenance not done, and so on and so forth. So whilst a municipality is obliged in law to provide services and to collect the amount that it charges those consumers for those services, it's obliged by law to do that. It's not optional. A consumer, on the other hand, is obliged by law to make payments of the charges that are lawfully due to it. So this is the purpose of today's webinar, is to ask, when do I have to make payment if I have some kind of dispute? Because it's very easy to say, here's my bill, everything is hunky-dory with it, I'm happy with 100% of the charges, and then you have to pay the municipality. There's no dispute there. But it's a little different when, for example, you have a residential property and there was a mistake with a meter number, and unfortunately you got a 2 million Rand bill. Now they're trying to cut off your electricity and your water, and you can't pay, but you don't believe that you need to pay. So the nature of today's webinar is going to focus on questions arising in relation to what are consumers' rights as against a municipality, specifically when there is a dispute. So Julius, we had a brief conversation prior to starting the webinar, and you had a series of questions that you'd like to frame the conversation in. Can I ask you if we can go through those questions, and then we can give context to the rights and obligations of a consumer, as per that question series that you had. It was very nicely laid out.
Yeah, thanks for that, Chantal. I think it puts a lot of context to the conversation. But yeah, let's jump into it. So help us understand, what are the common reasons for disputing a municipal bill?
So the most common reason is there's something wrong with the charge that is on your invoice. Now, that sounds pretty self-evident, right? You don't think that the charge is correct, but behind that, there could be at least 200 or 300 different reasons. So typically what you find is that most disputes arise in relation to more expensive items on your bill. Sometimes people look at these little things. It might be, for example, a water service levy for $20, and they go, oh, I don't know what that is, but it's $20 anyway, so I'm not going to dispute it. But this electricity, this is 5,000 Rand. It doesn't look right. I can't be spending 5,000 Rand, and so they dispute it. So the majority of your disputes are in relation to your higher charges, which is electricity, after that water, typically after that property rates, and then your refuse and your sewer are not usually massive charges. Although in the commercial context, your sewer charge can be very, very big, if not even sometimes more than your water. So on the commercial side, you're mainly going to be fighting electricity, water, and sewer, and then rates come later. So the reasons that your bill might be wrong, like I said, there are a million. And I promise you guys, every day I see a consumer who has a new problem that I've never seen before. It's practically unlimited. But the things that we see the most in our practice, and we represent clients all over South Africa, so we have a very broad view of what's going on. But the majority of clients who are looking for assistance are in urban centers. So what I say is more focused towards the larger metropoles than it is to the smaller rural centers. But typically your problems are, and I would say in order of frequency, I would say there's something wrong with my bill because the meter number, which is on my bill, is not the meter that's actually at my house. So the municipality is charging me for somebody else's consumption. That's probably number one. Number two, the second most common thing would be a water leak or a massive charge which has arisen for water, which you're unsure of whether it's correct or not. And that could have been theft. It could have been a leak, or it could have been from something that happens a huge amount, unfortunately, which is where a municipality doesn't actually take readings of your meter for electricity or water for quite a long time. And so what it does is it guesses how much you've been using, and it puts the guess on the bill. Later on, it then goes and takes an actual reading, and now it knows how much you've actually used. And it turns out that how much you've used is quite a lot more than the guesses that they had previously put on your bill. And the result is that you end up getting one big bill in 1 month for consumption, which actually should have been spread out over a much longer period in the past, and which you didn't even know probably that you were using. It might come as a big surprise to you that you've used all this water, for example, because you didn't even know about it because there was a leak and the leak was running underground and you couldn't see it. And the only time that you become aware of it is now the first time you see this giant bill. Oh my gosh, you go and have a look, get a leak detector, find the leak. So electricity problems are the most common, water problems the next, and then property rates. So this tends to be quite specific to different municipalities. The smaller municipalities don't usually have so much of an issue with the property rates, but the big metropoles do. And the most common issues are that people feel that the municipal valuation that is used to calculate their rate, remember, a rate is a charge which the municipality basically makes you pay simply for the luxury of owning a property. You don't get anything in return for it. It's not a quid pro quo. It's not service-based. And you just get this bill and then you've got to pay it. And the municipality has now valued your property too much. So they say your property is worth 2 million rand when you think it's only worth 1 million rand. And then basically in that instance, they would be charging you double the property rates that you think you should pay. So those are the most common reasons that you have disputes. But this is just the tip of the iceberg. There are a million reasons to see disputes. Would you like me to go into any of them in particular?
Yeah, I think before we go there, Chantal, I mean, now you're already giving us some valuable information on how to be a bit more proactive, actually actively monitoring your bills, checking whether there's a leak. Is that meter running, permanently in your property, to ensure that you ensure that your side is clean, because we almost want to get to a point now where we want to say, okay, well, so what gives us the ability then to declare a dispute, or when do I declare a dispute? And there's also this thing called a query. We've engaged with a couple of community members that said, yeah, I've lodged a query, but I think it's the same thing. Can you just give us some clarity on what's the difference between a query and a dispute? And then maybe let's go into, okay, so when do I declare a dispute? And you can go into that detail. I think some of the viewers would love that. Thank you.
So when we talk about the word dispute, the reason this word is important is because it comes from Section 102 of a specific piece of legislation, which is the Local Government Municipal Systems Act. Okay, now this is a bit different to the act I mentioned earlier, which was the Local Government Municipal Property Rates Act. We're not talking about that one, we're talking about a different one. So what this section says, basically, is that if you have, as a consumer, declared a dispute with a municipality about the amount of money that's owing on your bill, then the municipality is not allowed to take credit control measures against you. So by credit control measures, I'm referring to, for example, the disconnection of your supply of electricity or water to your property. Alternatively, most municipalities would do something like get credit controllers who work internally, or perhaps outsource debt collectors to harass you via SMS or email, send you nasty whatever SMSs telling you they're going to cut you off and all sorts of things until you pay. Or sometimes, in very, very rare instances, municipalities will issue summons for the amounts outstanding. But the most common way that a municipality will go after a person for debt outstanding by far is in terms of cutting off electricity or water. And just to note, it's really important to understand that we in South Africa, because of Section 102, we have this thing called a consolidation of accounts. And what that basically means is your municipal account for your property is like a giant potjie pot. And you must think of your potjie pot as the whole property and all of your services, whether it's electricity or water or sewer or refuse or any other charge that you get on your municipal bill. And the municipality can cut off your electricity if you haven't paid any of your charges. So some people tend to think mistakenly that they can cut your electricity off if you haven't paid your electricity bill, but where your other charges are fine. That's not correct. So you can have one service cut off for non-payment of another. So you can even have both of your services cut off if you haven't paid your rates, because it's all one giant big melting pot, and all of the accounts are consolidated or smushed together like a bunch of ingredients in a stew. When you pull out a spoon, you're going to get potatoes and carrots and onions and meat. You can't separate it out. You're going to get everything in one bite. So that's what your property is. It's this consolidation of accounts. So when we talk about raising a dispute, we have to be cognizant of what that means within Section 102 of the Systems Act. Now, there's a whole bunch of law on this because people have been debating this since the Systems Act came into play. But the word dispute, in essence, in law, it means that you are explaining to the municipality on reasonable grounds why you think the bill is wrong. So a dispute is not if you phone the municipality and you say, I'm unhappy that this street light outside my house hasn't been repaired. Okay, there you are laying a complaint about infrastructure. That's got nothing to do with your charges for electricity or for water, which are services, and you pay for based on your consumption through your meter mostly. And it's got nothing to do with whether you've paid your rates and taxes for your property. You can't say I'm withholding my charges for rates or sewer or refuse because the street light isn't fixed. So that type of query where you're saying I'm withholding some part of my payment because I'm unsatisfied with some other element of your function municipality, that is not a valid query. Okay, sometimes people call that a rates boycott. It's not lawful. In terms of when you are allowed to withhold, so this is when you have explained to the municipality, and I'll explain how you raise that in a second, how you raise that concern with them, but you've explained to them and given them information which proves that you have a reasonable suspicion that something is wrong with the bill, and then you've got to tell them why you think it's wrong. So you might log a query and you might say, oh, I think my bill is wrong because I went and I looked at the meter at my property and it's meter 123. But on the bill, it's meter 456. And I think that meter 456 is for the hotel next door. So you're actually charging me for the hotel's electricity. Or maybe you say something like, I got a R1,000,000 bill for water this month, and it says that I've used all this water, but I'm just a small residential home. I couldn't possibly have used all that water. Okay. So those are examples of reasons why you might dispute your bill. And it's important to raise with the municipality the reason behind why you think the bill is wrong. If you say to the municipality, I got the bill and I can't pay, that's not a dispute. That doesn't count as a dispute in law. So in order to raise a dispute, which is the very important thing that will protect you from credit control action in terms of Section 102 of the Systems Act, you have to follow the procedures that the municipality that you are talking to has written down in its internal policy documents and bylaws. Yes, now this is probably you guys are probably like, well, what does that mean? Okay, so every municipality has the ability to make its own laws, and this is what we call bylaws, and they should be available on the website. Every municipality can also make things called policies. Now, policy is kind of like a law. It's a little bit different, but basically it sets out a whole bunch of rules about a certain thing. So you might have a policy for water charges specifically for indigent households, or you might have an electricity policy for residential consumers or industrial consumers. So you can have policies and bylaws at the same time for the same thing. So you can have water bylaws and a water policy. So not every municipality has a policy for everything or a bylaw for everything. It depends from one municipality to the next. So Google is your friend. Most municipalities in South Africa have updated websites where you can find this information. Some of them, unfortunately, don't. So you can get most of the information from the internet, but sometimes you have to go into the municipality and talk to people, then ask them, where is your information about logging a dispute? Now, you asked me earlier what a query is as opposed to a dispute. So the legislation talks about us logging a dispute. Now, in terms of some municipalities' documents, it could be a bylaw, it could be a policy, they spell out what the dispute resolution procedure is. And this dispute resolution procedure has kind of got a standard methodology, but it differs from one to the next. So for example, let's take your big metropoles, Joburg, for example. Your first step to log a dispute is to phone the call center and log a query with them telephonically. And they give you a little reference number for this. If that doesn't work after however many days it says, 30 days or whatever the case may be, 21 days, 14 days, then you have to escalate it to the next level. So that's then a written letter of complaint. And then after that, if that doesn't work, you've waited 30 days or 10 days or 15 days, however many it says, in the policy, and it's not worked, then the last step will be escalation to the municipal manager where you're filing an appeal. So these words that I'm using, dispute, query, appeal, they vary from one municipality to the next in terms of their internal documents, which set out what the dispute resolution process is. So a query is in some municipalities exactly the same. It's equivalent to a dispute. But in other municipalities, a query is something less than a dispute. It's where you tell the municipality that you are questioning something. So you are there saying to them, I don't understand this. Can you help me with some information? Or you're saying, this appears to be wrong. Can you confirm? But in some municipalities, it's lesser than a dispute and it's not of the same weight in law. So that's why it's really important to understand what your municipality requires in terms of your municipality's dispute resolution policy. So Johannesburg, for example, I refer to it a lot because that's where I live. It's the most common to me. But Joburg, you log a query to start with at the call center. And then that's meant to be investigated by the municipality. And they are actually supposed to come back and say, hello, we have checked your query out, and this is the answer to your query. Guess what? Your bill is not wrong because actually it's correct and I verified it, and here's the story. Or, oh, thank you for raising this. You raised this query. You are right. Your bill is wrong because we accidentally charged you the hotel next door's water. So they're supposed to come back and tell you what the outcome of your query is. Very frequently, this doesn't happen. If you then don't get anywhere after you've logged the query, you then escalate it, you make it more formal, and you file a dispute. And that's got to be done in terms of a written letter. When your dispute doesn't help you because nobody's fixing it, you then escalate it to the next most serious thing, which is an appeal to the municipal manager. Now, what's really important to understand is that whatever terminology you are using here is not super important as long as you have complied with the basics of the principles. And that is, you have communicated with the municipality to say to them, this is why I think my bill is wrong. And you've explained that to them. And also, it's really important for you, as Julius mentioned, to be able to do things proactively, to be able to prevent disputes in the future. And one of these things is to keep a very meticulous paper record of absolutely every interaction that you have with a municipality, because you need proof that you have followed that procedure before you can escalate it to the next one. So if you are going to be speaking to a person over the phone, take their details, who you spoke to, at what time, on what telephone number, and ask them for a reference number for your call, which will then prove that you had that first interaction. Then if that doesn't work and you are forced to escalate it to take the next step in whatever the dispute process is, you then explain that this is the second step you're taking and refer to your prior reference number. When you're going all the way to the municipal manager, so you've tried everything else, it's not working, you go all the way to the municipal manager, who's your last port of call, you're filing an appeal. Now, an appeal is not only provided for in the municipality's dispute resolution documents, it also comes from the Systems Act, which I referred to earlier. The same section, sorry, not the same section, the same piece of legislation that talks about consolidation of accounts and disputes, it also talks about an appeal to the municipal manager. So you have the right in terms of Section 62 of the Systems Act, if nothing else has worked and you followed all those procedures, to actually go and deliver to the municipal manager proof of your dispute and all the rest of it and file it in an appeal. And then that municipal manager becomes responsible in law to look at that and resolve your dispute by answering you or by sorting out whatever the problem is. If you don't come right with that, in 2 municipalities in South Africa, it's only Cape Town and Joburg at the moment, you can go to the Ombud. There are special Ombud offices, which are public offices, which exist specifically to deal with complaints relating to Cape Town or Joburg. And if that doesn't work, you can approach a court for assistance. Now, you don't obviously, no one wants to go to court and no one wants to spend years going through the Ombud's office. So the idea is you want to try to empower yourself to be able to handle as much of this process without having to, for example, seek legal advice and pay legal fees. And the most important thing to remember here is, number one, document absolutely every interaction with every municipal official as in a detailed manner as best as you can. So even if you're talking about a a scenario where somebody arrives at your house and they say, oh, I'm from the municipality and I'm here to cut off your water, take a photo of them. It's not illegal to take a photo of someone. Obviously, don't be aggressive and go up to them and be combative about it, but take a photo of the vehicle that they arrive in. You might need that later. Ask the person, can I please have your name? Can I please have your contractor card to show that you are actually authorized on behalf of the municipality to cut me off? Do you have any documents for me? Try to get as much information about the municipal officials who you're speaking to, as well as the situation. Because when you have all of that information, you can follow it up with more ease if you've documented your process the whole way along. So what is a valid dispute? It's a dispute which in some municipalities you can call it a query, but in essence it's the same thing. It's where you go to the municipality and you say, something's not right here, this is my reason. And whether we're talking about a query or dispute in terms of the various bylaws or various policies, you should be okay. Our courts are quite good at recognizing that we have to look at the meaning, the real true meaning of the law, the substance of the law, and give effect to that, and not necessarily the to the letter, the way that it's described in documents. So it is very important though, please, especially if you're in the bigger metropolitan areas, when you speak to people over the phone to get a reference for your call, because otherwise the municipality officials can turn around and they can use the excuse, you didn't follow the right process when your dispute isn't resolved. Or they can say, oh, but you've never contacted the municipality about that. Meanwhile, you phoned them 50 times. If you don't have reference numbers for it, it can be very, very difficult to escalate it further. So that's what a valid dispute is. Any other questions on that?
Yeah, well done, Chantal. I think that captures it quite nicely, and thanks for explaining it so simply, so that we can understand it and follow. So let's say I do declare a dispute. I suppose there's some liability. Firstly, what happens if someone manipulates it? Our viewers are honest, but surely there's people who are trying to take a chance and sending inaccurate information to a municipality. That's one thing. But also, when I do declare a dispute, can I stop paying? And does the municipality charge interest on that? If you can help with some of those questions, and then we can carry on.
Okay, so in terms of municipalities and interest, let's start with the third one, which was your most recent question, and I'll work backwards. In terms of a whole bunch of different pieces of legislation, municipalities are allowed to charge interest on amounts that are outstanding. And what does outstanding mean? So it means that you've received your municipal bill, or maybe I should qualify myself. It doesn't necessarily mean it's in your hand or in your email. It means it's been generated on the municipal system and it should have been transmitted to you, right? So in a perfect world, we would all get our post every day and it would have our bills, or we'd receive an email. That we don't live in a perfect world. But unfortunately, the laws relating to municipal liability don't turn on whether you got your bill in the post or not. It's actually on the consumer to go and ask the municipality for a bill if they didn't receive it themselves. Okay, so just bear that in mind. But when you look at your municipal bill, right at the bottom, usually on the first page, there is a total amount owing, and then just underneath it, there's normally a due date. Now, that due date is the time when that amount is payable to the municipality. And if you don't pay it by that time, then you are overdue or your amounts are outstanding and interest will start to accrue. Now, how long is that date from when you receive your bill? Well, I never answer that question because number one, some people don't receive their bill. Number two, some people phone for their bill when they're not getting it. Some people get it in post. Some people get it 6 months later because snail mail is terrible. So that's why I say it's not based on the time when you receive the document. It's based on when the municipality generates it. So the payment date is a certain number of days from the generation of the statement date. Now, in terms of your municipality, there are going to be a specific number of days. So your ordinary period is about 14 days, but you do get some municipalities and some services, for example, in very big metropoles where there's huge amounts of electricity supplied to, I don't know, let's say a hospital, for example. then they would probably have a 7-day due date because the municipality needs to get the money back quicker. So it does depend as to exactly when your bill falls due, as to when interest starts accumulating. Now, the interest, if you are going to win a dispute because you've raised that there's something wrong and the municipality corrects it at a later stage, then the municipality must reverse that interest so that you are not ever required to pay interest on an amount that was wrongly billed in the first place. But municipalities are entitled to charge you interest. How much interest? Well, that depends on the municipality, which is supposed to take a resolution every year as part of its budgeting process, where it announces to the public every year, this is my budget and these are my tariffs. And this is how much interest I'm going to charge people who don't pay their bills. So there's supposed to be a resolution and a whole bunch of other things on the back end that support the municipality's right to charge interest. And we assume that they're there in most cases. There are obviously exceptions. So that's interest. The other question you asked
think,
was
Chantal,
about, yeah,
sorry to stop you there, but maybe on the same subject. So if a municipality basically gives me an exorbitant estimate bill because they generated it on their system, does that then incur interest? Okay, that's interesting. So
no.
can we dispute an estimate bill?
Yes. So an estimate is exactly, it's a guess by a municipality as to how much of a metered consumption service, i.e. water or electricity that runs through your meter, you have used. Now, this doesn't apply to other types of charges by municipality which are not based on a meter. It only applies to metered services. So the municipality, hypothetically, in a perfect world, would have lots of meter readers and they go around and they read the meters and they'd confirm how much you've consumed based on those meters. And in a perfect world, those meters would all work beautifully. They wouldn't be stolen. They wouldn't be so old that they've lost their calibration. They wouldn't be damaged by high pressure coming from the upstream when the reservoir was dry because the water wasn't managed efficiently. But we don't live in a perfect world. So all of these things could be a reason why your bill is wrong. And all of these things are a reason to dispute an incorrect bill. So going back to the issue of estimates, let's say that, for example, you get a bill and the bill is $5,000 every single month. And it says estimate, estimate, estimate. This is because the municipality hasn't had a meter reader to go out there and actually look at the number on your invoice, on your meter and say, this is the correct number. So the municipality's systems is using a algorithm, a calculation on its back end based on your prior consumption to guess how much you used. It doesn't actually know. And then it sends you an invoice which says you need to pay for this consumption. I don't actually know how much you've used, but I'm guessing. And that amount is then due unless you have logged a dispute. So when it comes to logging a dispute, you explain to the municipality why you think it's wrong. If you think it's wrong because you say, oh, municipality, I read my meter and I only used 1 kiloliter of water, but you've charged me for 25. If you know how much your bill is supposed to be, if you are able to calculate that, and not everyone is, because municipal bills and charges are flipping complicated. And secondly, there are all sorts of questions tied up with meters. Is this meter working? Is this meter leaking? Is there a leak underground? Do I even have a meter? Maybe it got stolen or whatever the case is. But if you are able to determine how much your bill should be, then the amount that you need to pay instead of the disputed amount, which is the amount on your bill, is how much you can calculate that it should be payable. But not everyone can do that. If you are unable to determine accurately what your bill should actually look like, then the law says that you have to pay an average of the 3 months of undisputed consumption. Okay, so that's quite a mouthful. What does that mean? It means that you go back to the last time that your bill was right and you look at 3 months and you say, okay, my bill started going haywire in January. So I'm going to go back to December. And then I'm going to look December, November, October. So I'm going to look at those past 3 months and I'm going to get an average. So I'm going to say, if I add all the 3 months together and I divide it by 3, my consumption was only 1,000 Rand a month. Then that estimated amount is the amount that you need to pay every month to the municipality, instead of paying the crazy incorrect account that you get where they're billing you for $5,000 every month, which is wrong because they haven't read your meter. So if you are talking about a metered service. Things are a little bit different if you're talking about a charge that shouldn't be there at all. So let's just say, for example, you are a residential property owner, and then suddenly there's a new meter on your account and it says you need to pay R1,000,000, but you know that that meter is for the property next door. In that instance, you don't have to pay the whole amount that's billed because it's crazy. It's not your consumption, it's for someone else. And you also don't have to pay an average of what the hotel next door was using. You don't have to pay anything because in that instance, the charge is not meant to be there to start with. So the average amount that you should be paying is zero because you shouldn't have any charge. So that's how to know how much money you need to pay when you raise a dispute. Now, if you don't pay the estimated average, so we're talking about a situation here where you know that you need to pay an estimated average instead of the amount on your bill, but you don't pay anything, or you pay less than that. That is a reason for a municipality to basically say, oh, well, your dispute falls away and you are not protected from the municipality sending you a summons or debt collecting from you or coming to cut off your electricity and water. So it's very, very important for consumers to understand that they have an obligation to make payments to the municipality, even in the instance where they are disputing the bill. Doesn't mean you have to pay the whole bill. It means you got to pay the part of the bill that you know is right. That's the undisputed part. You don't have to pay the portion of the bill you know is wrong. That's the disputed part. Aren't sure because you can't tell because the calculations are too complex, then you have to take a guess and you have to base an average off of your 3 months before your dispute started. When your bill was right, you use those 3 months to estimate. And like I say, if you don't pay this or you pay less than this, a municipality can cut you off for non-payment, and it can cut either your electricity or your water or even both, even though you've logged a dispute, because your obligation is to make payments of what you owe, alternatively, the undisputed average. And you have to keep up your side of the bargain just as much as the municipality has to keep up its side of the bargain and deliver all of the services to the people in its jurisdiction.
Thanks, Chantal. I mean, that's very clear. I appreciate that. No, I think in a nutshell, then you've got covered a lot, and I think it's answered a lot of questions. But I see there's a lot of questions that's still coming our way. So maybe just going to the floor a bit with our participants and their questions. There's the one question that popped up. Can commercial space owners lodge a dispute as well?
Absolutely. So this is not limited to residential properties. This is applicable to anyone who received a bill from the municipality, whether they are residential, industrial, commercial, whatever the case may be. Public service infrastructure, whether they are a school that is owned by Gauteng province. So even organs of state get billed by municipalities for their charges, and either they're exempt in terms of some other law or they've got to pay. So it applies to them too. I have seen instances where intergovernmental disputes arise. So you have a situation where, like, I don't know, the municipality of Cape Town bills Spoornet for its bill for water, and Spoornet doesn't pay, so then they go and cut off Spoornet. That's actually the right thing for the municipality to do, because it's under an obligation to collect its amounts. So yeah, it applies to every person or organization that gets an invoice for these types of charges from the municipality.
Okay, thanks. I don't want us to go too much into property rates, but Shane asked, can I lodge a dispute for an increased rates, when my objection appeal hasn't been finalized yet?
So yes, you absolutely can. And I also don't want to make this about rates, because like I said in the beginning, rates is actually quite a specialized type of municipality charge, and it is a compulsory charge. So it's not a charge that you pay because you get something back from the municipality, which is a bit different to electricity and water, because they give you the service and you pay them for it. Okay. So when it comes to rates, it's governed by the Property Rates Act. And a lot of people don't realize that. So they think that they can just follow the same normal process to dispute any other type of charge, the ones that I've been referring to earlier, which is log a query or a dispute, send a registered letter or a letter of demand, a letter of complaint, then after that, do an appeal. So that type of dispute is for credit control, meaning they are going to not cut you off or take other credit control against you if you've raised your dispute. Okay, so that's kind of what the billing section of the municipality. But in order to resolve the problem, if it's rates related specifically, you've got to go simultaneously to a different department at the municipality. This is the valuations department, because it's the valuation department at a municipality that deals with disputes and queries which arise specifically for your rates out of the Rates Act. So the two common types of queries here are, number one, how much rates should I be charged based on the valuation of my property? And then number two, is the categorization of my property wrong? So if you have a problem because you think your rate is too high, your charge is too high because your municipal valuation is too high, then you need to lodge that specifically with the rates department in terms of the Property Rates Act. Now, it gets a little bit complicated as to how you do this, but if you go speak to your municipality, they should hypothetically be able to guide you in how you lodge that query for rates specifically with the valuations department. And then on the back end, you're also going to log a query for credit control to stop them harassing you and come to cut you off when you've already raised your dispute in terms of the Rates Act. So you need to do two different kinds of raising disputes if you have a rates problem specifically.
Thanks, Chantal. And that's good information. Matt asked, how long do residents actually have from date of statement to make a payment?
I can't tell you because it's dependent from one municipality to the next. And it's also dependent on things like when your meter readers for your area read your bill. So you have different sets of meter readers for different areas. And based on that, the municipality issues invoices at a different time of the month. And then they provide you with a different payment date based on when your invoice is meant to be due. So unfortunately, that is something I cannot tell you as a standard. It's normally 14 days, but in some instances, it's 7 days. So you have to actually look at your invoice itself and see when it says your payment is due.
Well, that's also very valuable. No, thanks for that. You know, I'm looking at some of these key takeaways and I see we're almost running out of time. And I just want to maybe get into some of the detail of takeaways from this session. If I'm hearing you correctly, Chantal, we need to gather as much evidence as possible from the start of the process. We need to ensure that we follow the correct process as per our municipality, so that's what contained in their policy or bylaws. I'm assuming we can get access to this information, as you said, on the website, or maybe a local councillor can assist us with that kind of information, or a residents association potentially has those answers. But there's also ways of avoiding it, and maybe that's the best way to look at it. How can we avoid having to deal with a dispute in the first place? And what I'm getting from you is that we need to check our water bill or our bills, whether it's accurate, at the right property, because you can go quite down a road that you don't never had to. If that's the case, I think that's the lowest hanging fruit, if we could get out of a dispute resolution. The other thing is to avoid estimate bills by proactively submitting accurate readings, if it's possible. You've mentioned that it's not always possible.
If it's possible. So a lot of municipalities have a self-reporting function, and it's usually as simple as emailing photographs through or uploading it onto an app or whatever. but not all of the municipalities are actually technically able to integrate that reading information into their computer systems. So a lot of people, particularly in Gauteng, complain that they submit their readings, but they're not taken into account. And I know this is also a problem in relation to Eskom. So not municipalities, but it's a very widespread problem throughout South Africa. But if you can, and they are taken into account, absolutely, please submit photographs. And also keep a record of the photographs that you are submitting, because you might need them later if the municipalities lost your file or something. Who knows?
I think the viewers can add a lot to that. And then also by often checking leaks on your property, whether, because you don't want exorbitant water bills and it is actually your fault, but you don't know about it. What else can you think of? I mean, what else do you believe we can do to proactively avoid having to declare a dispute in the first place?
So I think that consumers, some of them, not all of them, some consumers like to think that if they didn't receive their bill in the post or they didn't receive an email, it means that they're not getting a bill or they don't have to pay. That's not correct. If you don't have an invoice from a municipality, you know what your monthly rate is, because it's the same for every period over a general valuation roll. So I'm not going to go into detail, but roughly 5 years, you'll find that the amount of money is exactly the same every single month in 1 year. Then next year it goes up a tiny bit for inflation. Then it's the same for 12 months, and then it goes up a bit for inflation, and so on and so forth. So you should know what your property rate is. And the same normally would apply to your sewer and to your refuse. Because in the case of residential properties throughout most of South Africa, the charges for refuse and for sanitation or for sewer are a fixed monthly charge, and they're not dependent on something like a meter. So, those kinds of charges, you should know off the top of your head every month what they are. And you should pay those to the municipality, even if you don't receive an invoice, because they are taxes and they are due and payable on a regular basis. And the other charges that you don't know because they metered consumption, can you take the argument, if the municipality didn't send me a bill, or it got lost in the post, or it ended up in China, or my dog ate it, or whatever the case is, can you use that not receiving a bill as a reason to not pay? Well, there might be an argument. It would be a very tortuous one. I wouldn't be the person to try and argue it in courts. You should be asking the municipality as a responsible citizen, in terms of your obligation to pay for services, you should be asking the municipality for your bill if you don't have one, in order that you can see how much you owe for metered services. If you have a situation where there's no bill available, and that does sometimes happen in very rare instances, maybe you've just moved into a property and your transfer's just gone through and you're waiting, and sometimes it can take up to 6 months for a municipality to create your account and generate your first bill. Or maybe there's a billing error. Okay, that does happen. Some big metropoles often don't release statements the first month of every financial year. So that's the end of July or end of August, because their systems are overrun and they actually don't have the capacity. So sometimes people get a double bill at the end of August instead of getting a bill for July and August. These things do happen. They're quite rare, but can you sit around and say, well, I'm not going to pay? Not if it's a standard monthly charge that you ought to know what it is. That defense is not going to protect you. So be proactive and go and get your bill. And rather than saying, I didn't get a bill for 5 months, and then having a big bill to deal with at the end and interest on all of those amounts, rather diligently pay every single month what you know you owe, or what you have calculated you think you owe based on estimates, so that it doesn't catch you at the end of the day and you don't have a massive bill that you then need to catch up. I think that's very important for consumers who are responsible. And then in terms of estimates, get your bill every month, and when you look at it, if you see estimate charge, estimate charge, estimate charge, you need to know in your head something is wrong somewhere. It's never supposed to go on for more than 6 months. So ideally, in a perfect world, we would not have any estimated charges and you would always get an accurate bill, but we don't live in a perfect world. So by law, a municipality has, in terms of water, it's usually 6 months, and in terms of electricity, it varies, but the bigger the consumer, like a giant factory, the smaller the period is. So it might be 1 month for a factory, but it might be 6 months for a residential household. It depends from one municipality to the next. But if you see repeated estimates, you need to say in your head, something is wrong. Go and have a look at your meter. Do you even have a meter? Has it been buried underground maybe? Was it damaged? Did somebody steal it? If the meter's actually there, look at what is on your bill. There's going to be a number. Okay, you don't have to be super smart to be able to just look at the number of the meter on the bill and then look at what your reading is, because it indicates it. So let's say your reading is 10. Okay, the municipality says your meter's at 10. But then when you look at your meter on the ground, it's actually sitting at 2,000. That's a problem, because you know that something is wrong there. Maybe the meter's not working, maybe the bill is wrong, but something is wrong. Don't sit and wait for the municipality to fix it. Go and try and figure it out yourself. And if you can't, get some advice. But go to the municipality and say, this is my query, this is my dispute. Municipality disputes, they go what we call stale over time, meaning that the longer you take to deal with and resolve the dispute, the harder and harder and harder it becomes to deal with them. People die, offices burn down, municipalities change their accounting systems, officials move departments. When you have a dispute that's sitting there going stale, it's not a good thing. It's getting harder and harder to resolve. So be diligent and try to sort these things out early if you can't avoid them. Don't let it sit there. And I know it's very discouraging sometimes because you feel like you're going to all this effort. I've seen people who email counselors 100 emails and nothing gets fixed. Okay, that's a story for another day, because it's actually not really within the realm of a counselor's job to be able to fix your things. But they are very nice people usually, and they really try to help as much as they can. But it doesn't help to send 100 emails to a counselor over 10 years. If the problem is not being solved, do something else. Escalate it up the ladder to the municipal manager when you file that appeal. Hand it to him or her personally and demand that this be sorted out. And if that doesn't work, if you've got an ombud, take it to an ombud. And as a last resort, if you're not able to get any help from elsewhere and you can't find any information on Google, you can always contact our offices. We do try to help, but we can't help everyone. And a lot of the time, our ability is constrained because we do so much pro bono work already. But we do try to help the public as much as we can generally when it relates to these kind of queries. So reach out.
Well, Chantal, you've helped a lot tonight, and thanks for giving us some clarity on this matter. I think it's at the hearts of many, and just for your time, we really appreciate it. Thanks, Schindlers, for that. And I just want to conclude, all your viewers, there's a lot of you still on here. Thank you so much for joining us tonight. Thanks for all the questions. Thanks for all the comments. And this video will also be circulated after this and worth sharing with other people that you believe should get end of this information. So thank you, everyone, and have a wonderful evening, and hope to give some more insights in the near future. Thanks.
Cheers.